This is Michael Popok, Legal AF After Dark, and it's dark and stormy coming in for Donald Trump. His ludicrous attempts to apply absolute immunity to let him commit crimes while he was in office is soon to be rejected by the D.C. Court of Appeals. First stop on the appeals train happens next week with oral argument. We're going to follow it only on the MeidasTouch Network and on Legal AF on its way to eventually being heard by the U.S. Supreme Court. But we want you to be up to speed on everything that went into the briefing, Jack Smith's filing for the special counsel, Donald Trump's ridiculous attempted use of fabricated evidence at the appellate level, citing anonymous sources and made up fraud claims in a brief and then using that in his own brief filed with the appeals court. I mean, we can't make this stuff up, but we're going to give you the guide for it. Only one place on Legal AF. Take a listen to our most recent episode where we break it all down and get you ready for that oral argument next week.
Both this frivolous contempt motion that Donald Trump filed before Judge Tanya Chutkan, complaining that special counsel Jack Smith is producing discovery voluntarily, and filed a motion in limine while there is a stay in place, while Donald Trump appeals the fact that the district court denied his motion to dismiss the indictment on absolute presidential immunity grounds. And then, Popok, I think we will also agree that not only will the D.C. Circuit Court of Appeals rule against Donald Trump on the issue of absolute presidential immunity, when this oral argument takes place in just a few days on January 9th, it is going to be brutal. They are going to tear him to shreds because he's done some things that are just so offensive to file before a court of appeals, setting aside the absurdity of his argument that he has this king-like immunity, that he says, even if you accept all of the allegations in special counsel Jack Smith's indictment as true, this is the type of stuff that presidents engage in. They always interfere with elections. They always try to overthrow free and fair elections. This is total outer perimeter conduct of what the Article 2 says the United States president is supposed to be. There's going to be so much pushback on oral argument. We're going to have the audio recording of that because that will be on audio, that oral argument, and that's going to be something to behold when that goes down. But also, in Donald Trump's reply brief that was just filed, he cites himself as precedent. He's like, numerous observers have said that the election was rigged. This is what Donald Trump's arguing. And then he cites his own social media posts and some random compendium of things that he said as the citation, not the court cases that he's lost, federal court cases, the Supreme Court case, not the case law or precedent. He cites himself. And that's one of the things that when we do this show, Legal AF, and throughout the MeidasTouch network, you know, this attack on our judiciary, this attack on our legal system, citing your own tweets, citing your own social media posts, it is so absurd and so offensive. And just for everybody keeping track, the D.C. Circuit Court of Appeals has an expedited briefing schedule. Trump's opening briefs were due on December 23rd. Then the answering brief by Jack Smith was due December 30th. On January 2nd, Donald Trump filed his final reply brief. So that's fully briefed right now. Oral argument January 9th there. And then you had these amicus briefs where third parties can submit briefs to try to persuade a court of appeals or district court or federal or Supreme Court on, usually in cases that involve kind of public importance. The courts aren't required to accept these briefs submitted by outside parties. Anybody can submit them. You can submit an amicus brief. And in this case, the D.C. Circuit Court of Appeals accepted the amicus briefs of a group of some of the top lawyers from 5 Republican administrations who all explain why Donald Trump doesn't have absolute presidential immunity and how the history, text, and structure of the Constitution would all be destroyed if there was this concept of absolute presidential immunity in criminal cases for former presidents for crimes committed while they were in office. But then there's that jurisdictional amicus brief filed by a group called American Oversight that says that a Court of Appeals here doesn't even have jurisdiction. There's a case from 1989 called Midland Asphalt. That's just the name of the company that was involved in the case. Justice Scalia, right-wing, now deceased, but right-wing conservative judge, strict textualist, basically said you can only take these interlocutory appeals, these appeals like in the middle of a case, as opposed to an appeal once there's a final judgment or conviction. There has to be some strict textual support or a statute that says you can do it that was passed by Congress, or something in the Constitution that says that you have this immunity or you have this right. And so in the Midland Asphalt decision, you apply it here. American Oversight said there's no strict textual anything about absolute presidential immunity. So therefore, Donald Trump was not permitted to even appeal this in the first place. Send it back to the district court for trial. Don't even hear it, DC Circuit Court of Appeals. Now, Jack Smith isn't taking that argument because I think Jack Smith actually wants a ruling on the merits that Donald Trump doesn't have absolute presidential immunity. Jack Smith wants to go to the guts of this case and not have a technicality, but I think he realizes that that brief's been submitted anyway, so he doesn't even have to go there necessarily. But the DC Circuit Court of Appeals told the parties, be prepared to address that brief submitted by the 5 former Republican administrations of top lawyers and the American Oversight brief. So it's a summary of what's going on. What'd you make, just go in order, Popok, that contempt filing by Donald Trump saying, stop filing things. You're filing too many things in the docket. I mean, how whiny is that? And then Jack Smith responds saying no. And then go through what do you think the DC Circuit's going to do on January 9th?
Well, on the Chutkan docket thing, and you and I have done hot takes on this, Judge Chutkan, and you read the order carefully, she stayed the case and any proceedings and things that she requires or the rules require to be done to take the burden off of the litigant, Donald Trump, while the immunity issue is up on appeal. You and I can debate whether she needed to do that or not. The Department of Justice and Special Counsel's Office argued, and it did not prevail, that there were certain other activities that could happen while the issue of office holder or presidential immunity, absolute or otherwise, could be determined by the appellate court, and the judge issued an order. And the orders didn't close the docket. It didn't close the electronic filing system. It didn't order the clerk to put the case on ice or stay it administratively, which she could have done. I've been involved with cases that have been stayed administratively while something else happened. And then you can't file things on the docket because the case is temporarily closed, if you will. The docket's open for business. And Jack Smith and his team can continue to file. The fact that Donald Trump selected to take the practice ball home with him while the game is still going on, that's up to him. You and I did a hot take. You and I did a hot take where I said, this is genius by Jack Smith. He has an open field. He can just file whatever he wants. Donald Trump's taken the position he's not going to respond to it because he'll be burdened otherwise. And so Jack Smith files all the motions. He stacks them up related to evidence in the future to be presented at the trial in March, as if we're going to trial in March, because we are. And as I've said before, if Donald Trump thinks he can sit around and not be preparing for this trial, hoping that he wins his appeal, and then come to Judge Chutkan and ask for mercy on the court judge. Judge, I've been sitting around. I haven't been preparing. I'm not ready to go to trial in March. I've been sitting around since November when I filed my appeal. That's not how that works. And so the teams have to be preparing for the possibility of a trial. If it doesn't happen, it doesn't happen. But if it does, they got to be ready. And Jack Smith isn't going to just do like a dump of like 13 things onto the docket at the last minute. He's going to file. He's going to submit things over to Donald Trump like evidence. He's not going to hold it to the last minute. Whether Donald Trump wants to look at it or not, the trial team needs to be preparing. So it's not that burden on the presidency that Donald Trump keeps talking about. If anybody's burdening himself, it's Donald Trump. He sends letters to the prosecutor saying, I'm going to ignore everything that you file. He files the motion for contempt. All that the order says is that Donald Trump doesn't have to. The rules that require response and briefing on a certain timetable are suspended, and anything that is required of him is no longer required. He's not required to do a darn thing. These are filings by the they are not proceedings. That's the conflation that Donald Trump has made that even his own lawyers don't agree with. Jim Trusty, one of his former lawyers, was on television recently, and he said, "Well, I've never really seen that when a party unilaterally files a motion or gives the other side discovery that's considered to be a proceeding, because it's not. It's not a proceeding." And that's the words that Judge Chutkan used. I think she doesn't even brief the issue, have the parties brief the issue of the contempt. I think she has the power to look at her own order and determine whether the filings by Jack Smith unilaterally on the docket and providing in the other side with evidence to keep the case on track for March is a violation of her order or not. I've had plenty of judges not wait around for the other side in federal court to serve their paper at all and just issued one of those minute orders we like to talk about with Judge Cannon in Florida that just says denied, no order to show cause. I think that's what's going to happen. Continuing the theme of embarrassing yourself in front of judges is this new filing that you just talked about in front of the appellate court for the oral argument next week. I think it pisses off the judges. It insults their intelligence. Donald Trump posted 2 days before an anonymous, unsigned, purportedly from election officials, election experts, a 32-page document that he posted on his social media. 2 days later, it ended up in the brief being cited not once, but 2 or 3 times as credible evidence. First of all, the record is closed. This appeal issue comes up from a trial court level where the record is closed. You are not allowed to, nor are you permitted to, submit new evidence that you've just conjured up and literally created for yourself, self-created evidence, self-fabricated evidence, and then cite to it. Trump on Trump, as we like to joke. That and these experts are so illustrious. They're so well known and well considered that none of them wanted to put their name on the document. So A, it shouldn't be part of the record because the record is closed and this is late produced. Secondly, it's not expert evidence at all. It's just self-created, self-fabricated junk. And he uses that, and his lawyers, who are now going to stand up in front of this panel, that's going to be led by Judge Pan, I believe, if I had to guess the judges. It's either Judge Pan or Judge Childs, I think are going to be. We'll see on the day of who's going to be presiding over this 3-judge merits panel that's going to hear this issue. But this is just going to piss them off, as you said. And I think at the oral argument, they are going to excoriate, they're going to roast the lawyer for Donald Trump that gets up and tries to argue about that presidential immunity should apply to have his indictment dismissed. And then you've got the watchful eye of the U.S. Supreme Court, which hasn't yet taken the appeal. But as we've talked about, these writs of certiorari, which are the requests that you make by a party who loses below, we're going to see a pretty, I think within 72 hours of the oral argument on the 9th, I'm thinking 12th, 13th, 14th, high velocity, we're going to get an order against Donald Trump saying that there is no presidential immunity, absolute or otherwise, especially on the facts alleged in the indictment, to have the indictment dismissed. And all these other crazy crackpot arguments that I wasn't convicted by the Senate, and therefore that's the precondition. That's against the weight of every Supreme Court precedent about what is the purpose of the impeachment process and how that doesn't implicate or stop criminal processes after somebody leaves office. Even something that was admitted to, and as was pointed out by Jack Smith, in Donald Trump's own briefing in the Vance versus Trump case that you and I talked about earlier in the podcast, he actually took the position that indictments and other criminal investigations of a president once he leaves office is appropriate and can go on. And of course, Jack Smith shoved that right back up Donald Trump's backside, put it in his brief and said, see, you want to quote yourself? How about your own briefs from 2020 in the Vance decision, where you took the opposite position? And so you've got all that going on. So all of those arguments, I think, are really just ridiculous, and they will make short work of them at this 3-judge panel level. And then we're going to have to sit back, Ben, and see what happens when Donald Trump takes the invariable request through John Roberts, who sits over the D.C. courts as the first line of defense as to whether these judges are going to take the issue. Supreme Court's going to do one of two things. They're going to say, writ of certiorari denied, meaning we're fine with what the D.C. Court of Appeals did. That's the precedent that's going to stay on the books. Or there's going to be at least 4 votes to take it up to the United States Supreme Court and let them make a ruling. If they make it quick on a fast docket, the kind of like the one that they just did on the ballot issue, which is at least a month from beginning to end with oral argument, then the trial is still preserved for March, late March, maybe April. If they take it on a slower track while the case is stayed, that's the death knell for the case to be tried before the DC election interference case, to be tried before the November election. So as you said, there was a lot of off-ramps and ways for the Supreme Court to make a decision. This one is at the heart of, I know they have a court of limited jurisdiction. They don't like to make constitutional decisions unless they have to. That's constitutional avoidance. I don't know how they avoid making a decision here. I think they play with the timetable to signal where they're at in terms of votes, but they're ultimately going to have to make a decision about whether this constitutional republic allows a president sitting in office to be immune from all criminal prosecution, no matter what he does. That can't be the law of the land, even among the right-wing MAGA on the Supreme Court.
Well, let's say the Supreme Court decides to accept certiorari and has on the issue of absolute presidential immunity. I think you and I both agree the following is going to happen at least. Donald Trump is going to lose before the DC Circuit Court of Appeals. They're going to laugh him out, and I think within 10 days to 15 days after oral argument, maybe even sooner, after, so like right around January 20th, before February 1st, we will get an order from the DC Circuit Court of Appeals affirming the district court rejecting Donald Trump's absolute presidential immunity claim. I think Donald Trump will try to figure out what he can do to, delay things, right? Jack Smith, I think literally the day of the DC Circuit Court of Appeals ruling against Donald Trump on the issue of absolute presidential immunity, Jack Smith has his petition for certiorari ready to go to the Supreme Court and ready to have the Supreme Court hear it. What that will then force is Donald Trump to then go to the United States Supreme Court and ask them. Donald Trump will ask Judge Roberts, who presides over the DC Circuit Court of Appeals and that kind of shadow docket there, to stay the mandate. Trump will also ask the DC Circuit Court of Appeals to stay their mandate from issuing, meaning telling the district court, the district court, Judge Chutkan, go on with your trial. Trump's going to try to seek a delay there. I think that John Roberts will temporarily grant a stay of the mandate, as they've done in these cases. Popok, it will be Donald Trump will declare victory that John Roberts gave us, a technical stay for a short period of time like he's done before. That's not what's going to be indicative of anything. But the question is then if the Supreme Court here's they'll have an expedited briefing from Trump, probably within 5 days. Trump, submit your response to the petition for certiorari by Jack Smith. Then if the Supreme Court hears it, though, that brings us to the first week of February, say the second week of February. Now let's say they use the exact same calendar that they used for the 14th Amendment, Section 3 disqualification cases, right, where they've set
1 month.
They basically have oral argument for 1 month. So then at the fastest, that would then push oral argument before the Supreme Court on the issue of absolute presidential immunity to be, say, March 8th or March 15th.
It could go faster, but it could go faster.
They could go faster, but say they use the same in their view that this is expediting. That puts it somewhere around March 15th. Now, in this interim period, you now have lost from December 13th to March 15th, while the district court proceeding is stay. You've lost 3 months, right? You've lost December, you've lost January, and you've lost February of proceedings while these dates are stayed. So for me, the earliest this point that the Washington, D.C. trial could be is a May to June. Even if you expedited this, as fast as you can, I think you're looking at a May to June trial date. And then the question becomes, with Judge Eileen Cannon, What is she going to do at this March 1st status conference? Because she set a trial date for May 20th, but I think you and I both know that Judge Cannon's not ready for trial on May 20th. I think Judge Cannon's games that she's been playing, if she really wanted to help Trump, she would have kept the May 20th trial date. She would have had Trump go through the trial, Judge Cannon. She would have picked bad jurors. She would have done all of these things. She would have allowed bad jurors to go in. She would have just, she'd play games a little bit differently, but she'd push Trump's trial to block out the rest of the year to focus on the document case. But she's screwed up her docket so much right now, Popok, that she's going to here's what's going to happen there. And here's why I still think the DC case goes first.
I'm going to give you the devil's advocate. I'm going to be the devil's advocate when you're done. Go ahead.
I think then what'll happen is at some point she's going to make a bad ruling. And then, that Jack Smith can actually appeal. Jack Smith will appeal to the 11th Circuit and then stay her proceedings. So her May trial date's not going to go because there's going to be an interlocutory appeal that Jack Smith has. She'll be stayed. And then I think you have the DC case sneaks in around May, around June would be my guess, mid-June.
So the devil's advocate is you may be completely right. The alternative is the United States Supreme Court and Justice Roberts has 5 votes on a policy decision internally that they need to have that trial happen, thumb up or thumb down, exonerate or convict Donald Trump before the election. If you're right that they don't care whether that happens or not, that's some sort of political issue that they don't want to dirty themselves with, and they're the Supreme Court and they don't care, then they'll put it on the track that you just described and it'll reach those conflicts that you just outlined. If they care about that, the way the federal district courts have cared about it, the way the federal appellate courts have cared about it and said so in rulings that we've seen out of the DC Court of Appeals that Supreme Court generally respects because it's a feeder program. A lot of those judges end up being elevated to the United States Supreme Court. If John Roberts cares about his place in history, the way that he was not on the Supreme Court in 2000 for Bush versus Gore, where in 72 hours they picked the president. Literally 72 hours briefing, oral argument, decision. This is his moment in time. Dobbs' decision gone. Constitutional right for women to choose, Roe versus Wade, on his watch, ripped out of the Constitution. He now gets to stand and deliver. And if he can get the votes to put this on a faster track than what you outlined, it will signal to me that they care the way the other federal judges do, that Donald Trump get his day in court, but that day in court happened well in advance of the election so that people know when they vote whether they're voting for an exonerated, indicted former president or a convicted former president. One way or the other, thumbs up or thumbs down. If that matters to them, then you'll see a much faster process than the one you just outlined, because when they want to do something, they can do it in 72 hours, 72 days, 72 weeks, or 72 months. They control their own docket. And by controlling it, the way we talked about the New York Times and how they are making a policy decision based on placement of articles on the front page and burying articles on the back pages, same thing here with the Supreme Court in their briefing schedule and how they manipulate that. So you and I will know right away, and we'll be able to talk about it here right away based on the briefing schedule. If it's as attenuated as you've laid out, this 1 month, and then we'll get around to a decision, and then you're right, then the chances of this trial going to trial, maybe there's still time left in the summer, is not looking good. But if they do things faster and they say, and we've seen it happen when they want to, no, we want to brief in a week, another brief, a reply, and the whole thing, an oral argument within, then we're cooking. Maybe we're cooking with a ruling, because the quicker they get to the decision making, you and I both agree that they're going to rule ultimately against Donald Trump on the application of absolute immunity to dismiss his indictment. The quicker they get to that decision and not F with the trial, the better it is for America.
And by the way, I think we are kind of saying the same thing. I just think the Supreme Court will view, if they set a 1 month briefing schedule from the time they get certiorari, I think they'll think that's fast. And I don't think that the Supreme Court justices, especially the fact that it's controlled by the 6 right-wing justices, I don't think that they care that this trial in DC goes before the Judge Cannon trial in May, or that they're giving any thought about, well, the Manhattan District Attorney case is scheduled for March 25th, and then what's Fulton County going to do? I just don't think, I think that John Roberts and the Supreme Court is going to move this. I think that they are going to say, okay, we could probably get this on track for a trial around, May or June if we issue a quick ruling in March. My only point is that at some point, Judge Tanya Chutkan is going to have to deal with the fact that already, Popok, there's been a month delay. You and I would both agree there's been a month delay, December 13th to when by January 9th, they'll basically be 1 month, right? Slightly under. So then that already moves March 4th to April 4th. Judge Chutkan is not, in my view, Judge Chutkan's not going to be like, I don't care that I stayed it. I'm going to ignore the stay and then keep all of my deadlines the same. I think she'll expedite it a little bit more. But to me, that just pushes March 4th to April 4th. And then you do that for 2 months, and that pushes it, again to May 4th. So that's why I think you end up having that trial probably sometime in May or June, if we're just being realistic. But then you have the Manhattan District Attorney case scheduled for trial March 25th, which is a felony case against Donald Trump. And that's going to creep up soon. And people are going to be talking about that case for the falsification of business records. So I think there will be at least 2 criminal Trump trials in 2024. And I still feel Donald Trump will be convicted of a felony in 2024. I'm very confident of those factors.
Well, there's an example of what we do times 5. We do a long, hour-long podcast called Legal AF, the pod. It's exactly what you think. It's on Wednesdays and Saturdays at 8 p.m. Eastern Time, only on the MeidasTouch network. Help them get to 2 million free subscribers. Use your thumbs and fingers. They're almost there. It's another 70,000 left. You could help be the network you've been looking for by helping the MeidasTouch network get there. And follow Legal AF. If you like lawyers who know what they're talking about at the intersection of law, politics, and justice, you've come to the only right place for that. And so if you know what I'm talking about, you love Legal AF already, we appreciate you. Take that clip. It's a great way to introduce the show to friends and family or people in your life. Send it off to them and ask them to join our journey. If you have no idea what I'm talking about, that was Legal AF. I am Michael Popok. And until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.